My name's Judith. I'm in the litigation team here at Law Squared, and my background includes insolvency and general commercial litigation. So today we're looking at directors' duties with a focus on your responsibilities in relation to insolvency. Today is targeted more at directors than lawyers or accountants, so we'll try and keep the law to a minimum and the practical advice to a maximum, and see how we go. So our first slide, these are the topics I'll address today. So all the basics, for some of you will know backwards, forwards, in and out. Some of you won't, so we'll go through those and see where we end up. I'm happy for people to ask questions as we go, or wait till the end, totally up to you. So let's start with insolvency at the beginning. So the Corporations Act provides us with a definition, which is as helpful as some definitions tend to be in the Corporations Act. So a company is insolvent if it's unable to pay all of its debts as and when they fall due. So I note the most important part of that is unable, not unwilling. So we need to differentiate between debts you don't believe you have to pay and those that you actually do. That becomes relevant later when we talk about statutory demands and other issues. So there used to be two tests to determine whether or not a company was insolvent. The courts have certainly made it clear now that they prefer the cash flow test. So they look at the amount of the current debts of the company, including when they're due and payable. They look at the current resources and the future resources of the company. And then they look at the likely date of receipt of anticipated income, knowing that, you know, some of those things are quite flexible. So the main issue is that all companies have, in my experience, times where they have temporary illiquidity. So you may be technically insolvent perhaps on one day and then not the next. So the court has certainly looked at that issue and said, just because you're illiquid for a short period doesn't mean you're necessarily insolvent. But there are other situations where companies truck along for quite a while with sort of a long-term chronic lack of working capital. Those are the companies that probably are insolvent and just sort of working their way through to survive. So why do we care about insolvency? So the Corporations Act extends directors' duties to the interests of creditors in an insolvency context. Directors can have potential personal liability for their debts if they're incurred whilst the company is trading whilst it's insolvent. Various transactions can be voided by a court at a later date, and creditors who receive payments from insolvent companies may need to refund some of those payments to liquidators to be put back in the pool for other creditors. Also, there are often insolvency provisions in loan contracts and other contracts the company sign, so you don't want to put yourself in breach of other obligations by being insolvent. So a fair summary of the three formal types of insolvency. Administration is always temporary. It gives, there's a moratorium on enforcement for creditors, save for certain secured creditors, and it only leads to three potential outcomes. So either someone got a bit excited and pulled the trigger too early and the company's solvent, it goes back to directors. I have never seen that in 15 years, but it is possible. The other option is that there's a director or a white knight who comes up with some cash, who wants to save the company, and they propose what's called a deed of company arrangement. That is voted on by creditors, the creditors accept it, and then the administrator tends to become the deed administrator, and the company trades for a certain period under supervision with obligations to repay certain creditors. The other outcome is liquidation, which we'll deal with next. So liquidation's easier because it's literally just you have to liquidate all the assets to pay the creditors. Liquidators have really significant statutory powers to pursue directors and creditors who've received money that the legislation says they shouldn't be able to keep. So liquidators also have, significant statutory obligations they have to honour. So it's a difficult gig. Receivership is the third type of formal appointment. This is usually used by secured creditors who have the ability to appoint a receiver. Often it's either to a specific asset or to all of the assets of the company if they have that right. I do find a lot of secured creditors, particularly banks, will appoint a receiver as soon as a director appoints an administrator to have someone in their corner as they see it to look after their rights while the company's in administration or about to go into liquidation. So what are your duties? You can see there that I've outlined the general duties that a director has. They're all the usual Section 180, 181, 182, 183 obligations. They're all fairly straightforward: reasonable care, good faith, don't profit from your position or information, don't have a conflict of interest, and maintain proper financial records. So I think it's Section 283 says that you must maintain financial records that are sufficient for you to know at any time what the position is of the company financially. That becomes a big issue, because if you fail to do that, there are certain presumptions that can be drawn that if you show a disregard for record keeping, that the company will be deemed insolvent during that period, which of course is very hard to sort of to disagree with, unless you can somehow come up with financial records that you should have kept at the relevant time, which is almost impossible in my view. Section 58G is the big one for insolvent trading. It imposes a positive duty on all directors to ensure that they're not trading whilst insolvent. So that requires, it really just requires you to be reasonable and to act really quickly if you have any suspicions about the company's insolvency. I've also set out there about the presumption if you don't keep adequate records. And also in Australia, you can be guilty of a civil contravention of this section without any intention to do so. You might think that you're doing the right thing by trying to pay, good creditors and continue supply whilst you're insolvent, but you're actually not doing the right thing, and ultimately it just blows back to you. In other countries, there requires an element of dishonesty, but not in Australia for the civil provisions. So, trading whilst insolvent. Whether you're insolvent or not is hard to work out for yourself sometimes. Oops, sorry. Screen's just going a bit weird. So I always think of it in terms of all companies experience some type of financial distress at different periods. But some companies experience, financial stress. Some experience financial distress. There's a difference. So in order for you to be held responsible, there are elements that I've set out there on the slide. You have to be a director at the relevant time that the debt was incurred. The company has to be insolvent at that time, and the company has to incur the relevant debt. So not a director, not someone else. It has to be the company. And there were reasonable grounds at that time for a director to suspect that the company was insolvent. So trading and incurring debts can also include, people forget that it includes internal decisions such as paying dividends and so on. So it's fairly important that you keep track of that. Okay, what are the risks if you trade while insolvent? So this is the nasty stuff. So potential penalties up to $200,000. Orders to compensate a company to the amount of the relevant debt. And if there's a criminal breach, which does require dishonesty and is usually accompanied by some sort of criminal conduct, like fraud, and ASIC prosecute, they can also not only fine you a lot of money, but sentence you to serve some time in prison. That has happened to a number of directors who have acted very dishonestly. The last minute transfer of $500,000 to the wife just before things go south, not smart. Where are we? Okay, so of course there are defences, because none of this is clear. I should say the defences are only to the civil breach. They're not to the criminal breach. That's a different matter. So the first one is that you had reasonable grounds to expect and did expect that the company was solvent and that it would remain solvent after you incurred the debt. So we've got enough money, we're going to be okay. We'll have enough money when it's due to be paid. The second is reasonable reliance on information provided by others. So you don't get to just delegate to your CFO or to any other staff member. You have to actually rely on someone who has all the relevant information they need and who has expressed to you an opinion that they believe the company is solvent, and you rely on that. Absence from management is an interesting one. Usually you have to be either completely, on 6 months leave because you're very unwell, or out of the country and not participating in management or so on. But the courts have certainly taken a very narrow approach to that. So you can't just be on holidays. You have to really be completely absent. The other one is taking reasonable steps to prevent the company from incurring the debt. So I have seen this in the past where one director will have an issue about solvency, the other directors do not, often because they're committing fraud in the background. But that director can call a meeting. He can say, listen, we can't be incurring this massive debt. It's not sensible. We'll be insolvent. I'm not going to permit it to happen. And get all of that on the record, because basically everything will be looked at, through the 2020 vision of the retrospective judgment of a court or ASIC. So you can make a fuss and say, I object to this course. I won't be involved. Usually then you'd resign as well, which would be probably the smart thing to do.
Can I ask a question?
Yes.
If a director keeps tipping money into the company for it to pay its bills, would that be considered taking reasonable steps?
Assuming that they have a loan, assuming that it's an actual loan to the business, they're not just tipping it in out of love or joy, potentially.
It actually allows them to offset it against any claim. There's actually case law on it. So if you tip money in and then you're pursued, you can actually offset it against any insolvent trading claim.
Yeah, interesting. Okay.
Correct. Yeah. Yeah. Okay, so how does this all work in practical terms? So ASIC has been very helpful and published 4 key principles for directors. So actively monitoring the solvency of the company, investigating any financial difficulties that come to your attention, seeking advice where you need that advice, and considering that advice and acting in a timely manner. And when I say timely manner, very swiftly is the key. So, going back to those. So actively monitoring, I'll give you some practical tips in a minute, but that means staying on top of the solvency day to day, month to month, quarter to quarter, year to year. And it means making inquiries when you don't have the information that you need and making sure that you read everything that you're given as a director. So investigating financial difficulties is if you work out that, bills are not being paid on time, you've got to ask why. How long is it going to be? What plan do we have to pay this bill? What's happening? The seek advice is really about when you're kind of very concerned and you want to get an expert opinion about the solvency of the company. And we can help with that because there's lots of really smart accountants who can come in and help you. And then 4 is if you do get advice, rely on it and act on it. So if you get paid for the privilege of having a solvency report, and someone says this company's in trouble, you want to act within days in order to avoid the wrath of ASIC. So best practice. So obviously make sure financial records are kept. Make sure that all your financial staff is adequately trained and that they can provide, create and interrogate financial records as needed. So have a good system to keep all of that in place. Obviously, this will vary depending on the size of the company, the complexities of the company. Read everything that you're provided as your role as a director. I know it's profoundly annoying because you get a whole bunch of stuff for meetings, but read it. Assess whether you've got enough financial information. There's nothing wrong with you going to your accounts department and saying, I know I've got this report, but can I have the assumptions on which this is made, or can I have this other information, or what does this mean? Also, do whatever you need to do to understand the financial position of the company, because it's your head ultimately on the block if you don't. So I would never be shy about that. There's also quite a bit of comments from ASIC and a little bit of case law that indicates sort of monthly monitoring of financial positions is probably sufficient. Annually is certainly not. Quarterly would be good too, but I think monthly is obviously the Rolls Royce of monitoring financial positions. What do you do if you think you might be insolvent? So we can put you in touch with good quality insolvency practitioners who can certainly help. I've seen them add a lot of value in my time and really help businesses that might be struggling or might have small insolvency issues deal with their issues and come back to life. Stephen Dixon, who's in the room, is certainly on that list. Also, there are other options that might be available to you. There's a safe harbour regime that's available to companies, who genuinely want to fix whatever's going on in the company. I've listed there a few of the issues with safe harbour. I mean, you've got to have all your employee entitlements up to date. Unfortunately, it seems that a lot of directors skip super and tax before they do other things. All your taxation reporting obligations need to be up to date. The government is currently considering relaxing that from all taxation reporting obligations to a certain list or a substantial compliance, which terrifies me. And also, you've got to work with a restructuring expert to formulate a plan. So the only way you can use Safe Harbour is if you have an actual plan that you can sit down with someone like Stephen and work out how can we actually save the company and get a better result than if we appointed an administrator. And of course, you have to tell people that you're using the Safe Harbour regime, which sometimes makes people nervous, but it's important to comply with that. So moving on from insolvent trading and a couple of sort of related issues. So creditor defeating dispositions are always an issue. These are often done, usually I find that they're done by someone who's deliberately trying to defeat a creditor. Sometimes people do it inadvertently. So again, this is selling company assets to a new company and leaving all the debt in the old company. Selling them for half of what they're worth, selling them to a relative. Plant and equipment should not be sold to wives or sisters or brothers. So there's a definition within the Act which says that the transaction is, the consideration is less than market value. The disposition has the effect of putting the asset and the funds beyond the away from creditors. And there was no proper purpose for the undervalued transaction other, than potentially to put it out of the hands of creditors, which is, not, of course, not a proper purpose. These are really easy to avoid. There's nothing wrong with moving assets between companies and for other reasons. All you have to do is obtain an independent valuation for any property, particularly if you're worried about solvency and other issues. And ensure there's a proper purpose. So there may be a taxation issue, there may be other issues that require you to transfer things amongst entities. Just make sure that you do it with a proper valuation, and then no one can complain. So, of course, this leads automatically into phoenixing activity, which some people get very confused about, named, of course, after the mythical phoenix that rises from the ashes. So phoenixing was a massive problem in Australia for a long time, still going on, but a little less in the background now that the government has legislated to make a whole bunch of people liable, including legal practitioners who assist. It is completely legal for people to restructure their companies and move assets and liabilities around, completely legal. What you can't do is take all of the assets out and put them in a new company and then leave all the liabilities in the old company and put that into liquidation. And usually it's dishonest, usually it's leaving behind employees or tax debts primarily. There are dire penalties, including fines and imprisonment if fraud is involved. And again, independent valuations are handy. Really, the best advice I can give any director is that you just look at your actions in terms of how will this look in 2 years' time if someone's looking back on what I've done, because that's what will ultimately happen. I think too, construction industry was massive for phoenixing, and they would just simply, 1 week you'd get an invoice from one entity, next week you get a fresh invoice from a very similarly named entity, and people would inadvertently continue on. The government has I think most of you are probably aware, the government has a system where they pay employee entitlements, and at the moment they are bleeding cash and keen to recover it. So they have a very well-funded group of lawyers and people who are stepping in and dealing with these things in the courts. So when do you need to hit the panic button? When do you need to call me in particular? So, don't worry, no one's ever happy to see me, and I'm fine with that. But these are the times when directors just really need to pick up the phone. So stat demands, which I'm sure most people are aware of, generally they expire after 21 days of service. During COVID, there were all sorts of changes to deadlines, including pushing things out for 6 months and other annoying things. And, you know, increasing the statutory minimum from, it used to be 2,000 in the heyday, and then it was 20. I think it's still 20. This is one of the things in law, probably the only thing I'm aware of that is it has a finite and absolute deadline. If you fail to comply, the burden shifts from the creditor to the company to prove that it's solvent. So there's a presumption. These are highly technical documents for a reason, because they're so powerful. So often they're defective. I see lots of firms that stuff them up all the time. So best to give us the document immediately and we can tell you whether we can have it set aside or not. The debt has to be a liquidated sum, has to be due and payable, and not the subject of a genuine dispute. So what most people do when people are demanding debts is they raise something in correspondence that looks like a genuine dispute to try and avoid a statutory demand. Not always successful. So if it's not withdrawn, or if you don't apply to set it aside and it expires, the presumption will operate, and there is no ability for any court in the world to extend the time for compliance. So you are stuck having to prove that you're solvent. So proving solvency is frightfully expensive. The cheapest I've seen is sort of $15,000 to get a solvency report to prove that your company's solvent. And then you have to go to court. So all up, I'd say it's a $30,000 exercise potentially, which is simply avoidable if you don't let the deadline expire and you deal with it in a timely fashion. So standard director penalty notices, there are two types, but we'll only really deal with standard today. The other is not as common. So I believe the ATO has a stack of these to be issued probably starting July 1st. Fingers crossed. Sorry. I'm really very nice. Anyway, so yeah, there's currently a lot of outstanding debt with the ATO, and due to COVID and due to all of the trouble that everyone's had, they've been very sensibly not pursuing people, but that will end. And I know that most people are doing their best to pay their tax debts, but some are not. So if you have outstanding PAYG or super, you can be issued with a director penalty notice. These are also a powerful tool. So you have, I've said only 3 options there, but there's 4. And all of them must take place again within 21 days. So you can pay the amount that's set out in the notice, which of course I recommend. You can appoint a small business or restructuring practitioner if the debt's under $1 million. You can appoint administrator to the company or appoint a liquidator. You used to be able to reach an agreement with the ATO to sort of pay the debt in, portions as suited your business, and that would deal with the notice. That is no longer available. I mean, the ATO will always negotiate with you because they want their money, but it won't protect you from the operation of the DPN. So if it expires, as a director, you then become personally liable for every debt, every cent in that director penalty notice. So if you get a $200,000, director penalty notice, you then become personally liable. So it's your house, your car, your life that gets blown up by that. So you really want to avoid that. So that's another thing to bring to us as soon as it arrives. So that's pretty much all I wanted to address this morning. I appreciate I've kind of gone through things on a high level. So if anyone has any questions, please let me know, particularly practical questions about financial documents. So for example, you have your projections and obviously you're working against your projections. I think some people often forget that under those projections are assumptions and you just don't revisit them for like 2 years. And you're like, no, we really need to revisit those because they might be incorrect. So I think it's just a matter of being super diligent, staying on top of stuff, having a really good system in place so you know at any time, you know, how good or how bad the balance sheet is, and just asking for help along the way. Do you have anything to add, Stephen?
Probably only a comment I'd make, Judith, is in relation to determining solvency. If you look at the water bill case, that provides the 10 guidelines to solvency, which probably would be worth circulating to everyone.
Yes, I can do
That
that.
provides you really good guidelines in relation to what the courts look at for the definition of solvency.
Yes.
So, yeah, that's probably one comment I'd make. The other thing I haven't seen in, and you and I have been doing this for 20 years, very rarely do ASIC prosecute, especially for insolvent trading. It's normally just the liquidator or whatever taking the civil action rather than any criminal. Very, very rarely so.
Well, that was interesting. You just mentioned water bill. That's probably the one exception
To it, yeah, exactly
because they wanted to get John Elliott.
Yeah.
Yeah, they do like a big fish.
Correct. That's my experience. That's exactly what it has been.
And
Yeah.
an arrogant director with a lot of money is perfect for them. But I should say liquidators have, you have significant powers. You know, you can examine a director.
Yeah.
That is hideous. I've had to act for directors and for liquidators in that process, and sitting there watching people in a witness box squirming and trying to tell the truth most of the time. Not all the time, but some of the time. But also, you know, I literally don't remember what I had for breakfast yesterday. So I certainly don't remember what I was thinking when I made a certain decision. So that's the other thing about note keeping and minutes of meetings. And I know minutes are a pain in the neck and everyone hates them, but they are so important because when someone like me or someone like Stephen or Ahmed goes back to sort of work out what was everyone thinking, what was everyone doing, you know, it's all there. Yeah, so really I just always think of, and this is the way I practice law with strategy and communications with other lawyers and everything else. I think, how is this going to look in 5 years' time if someone looks at it? Or what would a judge think of this letter? Or what would, you know, just so that you're kind of consistent with your values, you're consistent with your strategy, and it's kind of clear what you're doing and why you made certain decisions. I think that's the key. Because, I mean, ASIC, you're quite right, but certain liquidators will come after you no matter what, particularly if you have any assets. But I think it's much easier to have, here's all the evidence of me trying to do the right thing, and liquidators are generally not unreasonable then, rather than, I'm not telling you anything, I was doing the best I could, you know, sort of thing. So I think, again, it's kind of like being at sea, you know, put your hand up. The sooner you put your hand up, the sooner someone can help you too. Don't wait until it gets, you know, unbearable and people are bashing down your door. So yeah, also I think the other important thing that I think every director should be looking at meetings or at least once a month is aged creditors and details of any arrangement you have with a creditor. So why does this guy have 7 months to pay this back, you know? Or why are we paying, more importantly, why are we paying this back at 7 months? Why can't we pay this earlier? So focusing on that sort of thing.
I have a question as a non-lawyer and no legal background, so excuse me if this sounds ridiculous. On the flip side, so I worked for a company, obviously it's not this one, that has recently become like no longer, and they owe me a lot of super and pay.
Yep.
And I've been told I'm not going to get any of that from back in the day because they just traded 5 years knowing that they were in so much debt. Is there anything that you can actually do about that?
So they're in liquidation?
Locks on the door, everything. Yeah.
Okay. So I think you should, have you contacted, no, it's not Gears, what is it called? FEG, thank you.
Yep.
I'm constantly trying to go back 15 years in my head. To the heyday, I like to say. Yeah, so have you contacted FEG, like the Fair Entitlements
I don't know what
Guarantee?
FEG is.
I can help you with that. We can help you with that.
Great.
So certain employees have priority to certain types of payments. It's not always your holiday or your long service or whatever else. There's some very complicated, painful rules about all of that that we don't need to discuss this morning. But the federal government guarantees certain payments to you, and then they seek to recover it from companies. They're subrogated to your rights. Step into your shoes and recover things. So, well, we can have a chat about that.
Okay. And
Yeah.
the directors of that company are just in Tasmania living their best lives.
Yeah, the other
Avoiding
thing.
all
Well, the other thing I
prosecution.
didn't. The other thing I didn't mention was that you don't get too many goes at this either. So, like, if something goes wrong with your first company and then something goes wrong with your second company, you can get banned, you know, for 5 years for being a director. I've got one at the moment where I've written to the liquidator and said, by the way, I know that he'd resigned as a director, but he was still approving, you know, he was still acting as a director for all of this period. And this is the third company that's gone into liquidation. Do you think you want to refer this to ASIC and have him dealt with? So you sort of don't get too many free kicks. So if those guys have done this before and have form, you know, it's worth potentially having someone contact ASIC. The problem is with liquidators, if they don't have any assets, and the government is talking about there's an assetless administration fund, stupid words. So, sorry, it's very hard to say. And at the moment you need some whiff of dishonesty, don't you, to get the 5,000. They're actually talking about changing the law so that every administration that doesn't have assets gets $5,000, regardless of whether there's dishonesty or not, which would be great, except that $5,000 doesn't go very far at all to do much. But liquidators can only do what they can do when they have funds. There's obviously a whole raft of things they must do, even if they have no money. But yeah, some liquidators are more inclined to follow things than others.
Yeah. Okay.
And some can't follow things. You know.
If you are owed super though, contact the ATO, because the super is a personal liability of the directors, and the ATO will actually pursue that superannuation for you.
Okay. Good to know.
So go and contact the ATO.
We'll give you all.
It adds up over time.
Absolutely.
It does.
Oh no, you've got to do it. Yeah. You also the benefit of doing that is to stop them from doing it again.
That's my main.
Yep.
My main reason.
And there must be other employees in the same
Yeah,
situation that you know, and there'll be other creditors.
Yeah.
I have a question. What sort of things do you think we should look out for in the current environment for key suppliers that are looking a little bit suspicious and not solvent?
Yeah. So round payments. If they sort of owe you, $1,265, $12,650, and you're getting like $10,000 sort of for each sort of thing.
And they're a supplier, so we buy a key.
Oh, sorry. So from your point of view.
Yeah.
Or
so
whether you want to know if the suppliers.
what sort of things I can look for on the sort of.
Yeah.
In the
Hard.
relationship?
It's sometimes quite hard to tell because they can cover it up quite well. Some of them run that little pyramid scheme where they take money from one person to the next and then keep supplying. I don't know. Stephen, do you have any? Look,
you could do, like there's Creditor Watch where you can do a search on there to see if there's got any defaults against the company. That's one of the things we do occasionally.
How much does that?
It's relatively cheap. It's probably $30 or $50 to do a search on a company with the Creditor Watch. And it gives you their feel for what their payment history is like. So that may give you, and I certainly will provide any details of any default judgments that's against the company. So that's one. The other thing that will also do is provide you details of who holds security against that company. So if they're only made to banks, any other financial institutions with leases, that sort of thing, because of the PPSR legislation.
Yeah.
So that's one thing I would do.
Yeah. I mean, if they do owe a bank a lot of money, I mean, they wouldn't let something go on Creditor Watch, would they? Like the Commonwealth Bank would be.
Oh no, the banks have been very lenient over the last couple of years.
Have they?
Yeah. The other thing that's about to take place is that debts over $100,000 will be ATO debts will actually now be listed on companies. What's the organisation that's got the right?
Oh, Credit Watch.
Credit Watch and Equifax are about to have both of them. So if you subscribe to any of those, they'll actually tell you if the company owes the ATO more than $100,000. That's good. The problem with that, it's going to have a massive impact on companies' ability to refinance and gain additional finance to get themselves out of trouble. So it's a two-edged sword.
The other thing is it'd be hard for them to get it taken off.
Correct.
Because with the ATO, you file one document, that goes away. But it'll take I've tried to remove things from Credit Watch for clients. It's
Yeah,
a
it's
nightmare.
very hard.
And also
Right.
they make a lot of errors, to be quite
Yeah,
frank.
no, you're right.
They really
Fair
do.
observation.
I've had a lot of clients who are co-defendants in a proceeding, and if there's a judgment against one of the defendants, it's listed on everyone's credit, sort of thing. So those are great, but they're only, again, indicative. So it's hard to watch. It's hard to know exactly what's going on.
Yeah.
But that's a good place to start.
Great.
Hi Judith, I've got a question. Is the 21-day period able to be extended? So in a circumstance, say if a director is ill and it's been served with a DPN during that period, other than negotiating with the ATO, is there any other way you can apply to the court for an extension if there's sort of like an extenuating circumstance?
That's an excellent question, Natalie. No one has ever posed that, and I've never seen anyone do that.
I think
Have
you can. I think you actually
Yeah.
make an application to
Okay.
court.
There you go.
The DPNs are virtually impossible to get extended.
Yeah.
But stat demands you certainly can get extended.
Oh, stat demands you can, yes. But
DPNs, no hope.
you can get a stat demand extended if you apply before the 21
Correct.
days.
Exactly.
If you apply after, you cannot.
Yeah.
And unfortunately, I've seen a number of legal practitioners learn that the hard way. But DPNs, I've never seen
No, you
anyone
won't get them extended.
extend them.
No hope.
There's
Yeah.
a power, but
I mean, I imagine that it could happen,
it
but
Possible.
It's difficult to do.
I've never seen it happen. Yeah, I think usually too, by the time, like they're not issuing DPNs for $5,000, it's usually a significant tax debt. So people are often at the pointy end
you're right.
already.
She's gone.
She's
She's
gone.
she's the answer to the question.
And she's left.
I did like, thanks Judith.
No worries. Okay. Sorry, any other questions before we? Do we eat pastries?
Oh, yeah, there is a question here from Elle. What are the liabilities and responsibilities of directors who suspect or can show dishonest trading by past directors?
Good question.
That is a good question.
Oh, it just fills me with dread. Look, I think it depends on the impact of the conduct. So if it's something that's been remedied and there is no repercussions for anyone, for example, I know that I've had directors come to me and they've had staff steal money from them and then put it all back. Amazing. And that's an issue and that's horrible and it would have affected them during that time, but it's kind of almost a victimless crime in that it's remedied. There's no need to be reporting it to anyone or doing anything because it's kind of dealt with. I think really it turns on whether it has a significant impact on creditors or anyone else to which the directors owe a duty, so shareholders, etc. That would be my view.
Okay. Elle, does that answer the question? Any further?
The other thing, bear in mind, even if a director's resigned, it actually doesn't get them off ATO debt from the past. They can still issue DPNs even if the director's resigned.
Yeah, I mean, resigning, like,
Doesn't
doesn't-
resolve those issues.
yeah, it doesn't have a retrospective application at all. You'd kind of have to have a crystal ball if you wanted to successfully resign before bad stuff happened. The other factor is too, let's not forget that you can resign, stay in the business and be deemed a director.
Yes.
I see that a lot. You get the dodgy ones resign because they know they can't remain as a director. And courts will, if you are acting in capacity of a director or if the company is accustomed to acting on your direction, you're a director, whether you're on the ASIC register or not. So you can get yourself in a lot of trouble without formally being a director.
And that can apply to the accountant as well, the company's accountant,
Yes.
if they get too involved.
Well,
We've
it's
seen that.
happened. It's happened in the bond matter. It happened to
Correct.
financiers who were attending directors' meetings, and be careful how far you get involved with businesses if you're not on the hook. Certainly.
Are there repercussions for directors that are sort of have multiple director positions, but in one of their companies they've intentionally been in trading insolvent? Like, are there sort of flow-on effects So say that same company that's a key supplier is also a director of my company, and could there be any sort of impacts that we can pursue as a?
If it's civil trading whilst insolvent, which of course is, can be done without any intent, and often is done as a result of people trying to have a positive intent but not understand their obligations. I don't think that affects your directorship of other companies unless the punishment for trading whilst insolvent includes you being suspended from being a director.
Yeah, okay.
Yeah, because it's very common. I've had clients who've come to me and said, well, running a nursing home, I had to keep paying for the food because people had to keep, do you know what I mean? And I was like, well, I get it. You should have appointed an administrator 3 weeks ago. So a lot of that stuff, people at ASIC courts are not going to get upset about it unless it's, some pretty bad behaviour.
Yeah.
Yeah.
The only other possible contagion would be if you've got a holding company. So if you've got a subsidiary that's insolvent, it can actually lead you up to having a claim against the holding company. So you just got to check your structures out.
It's true. Yeah. No worries. Anyone else? Any burning questions?
I don't think so.
Okay.
Thank you so much, Judith. Thank you.
Thanks, Judith. Well done.
You're welcome. Thank you, Stephen, and I'm for your assistance.
Pleasure.
We will obviously upload this and send around the slides as well. So you can take those away. And again, thank you for attending. Please have yourself your pastries, coffee, everything out in the lobby, reception, I should say. And yeah, thanks again, Judith.
Yeah, well done.
No worries.
Thank you.
Judith.
Have a chat then.
Is